Good evening, everyone. My name is Rachel Daly, and I'm the president of the Federalist Society chapter at UVA Law. Thank you all for tuning in this evening for this important and timely discussion on the future of qualified immunity. Before we get started, a few housekeeping items. At the end of the program this evening, we'll have ample time for Q&A. So there are two ways that you can ask a question. You can type your question into the chat box, which will make it visible to the moderator and the panelists. You can also use the raise hand function in Zoom and wait for the moderator to call on you, at which point your audio will be unmuted and you can pose your question to the panel. So I will just briefly introduce our moderator, Philip Williamson, before I turn it over. Philip graduated from UVA Law in 2013 and is a litigation associate at the Taft Law Firm in Cincinnati. Before joining Taft, Philip served as a law clerk to Judge Kethledge on the Sixth Circuit, Judge Thapar on the Eastern District of Kentucky, and Judge Smith on the Eighth Circuit. So thank you, Philip, for moderating our discussion today, and I will turn it over to you.
Thanks, Rachel, and thank you to the UVA FedSoc chapter for letting me moderate this evening. Everyone dreams of getting a chance to come back and speak at their alma mater, so it's a treat for me to get to do this even virtually. As I'm sure many of you know, qualified immunity has been a bit of a hot topic over the last several weeks as we've seen both high-profile police-involved deaths in 2020, as well as some other fairly expansive intrusions on constitutional rights, which I'm sure Mr. Breckenridge is going to tell us more about in a moment. But I first want to briefly introduce our speakers, and while there are many professional highlights to hit, I'm going to try to keep this short because I think you want to hear from them rather than hear me talk about them. But I'll begin with one of my favorite professors from my time at the law school, Professor Barbara Armacost. She is a double who with a Master's of Theological Studies at the University of British Columbia and a nursing career sandwiched in between. And after an illustrious career at the law school that included the Miller Prize for an outstanding graduate and serving as notes editor for the Law Review, Professor Armacost clerked for Judge Harvey Wilkinson on the Fourth Circuit and served as an attorney advisor in the Office of Legal Counsel at DOJ. She returned to the law school in '92, and if you are lucky, you're going to have her for torts this fall. If you're smart, you'll take her for everything else she teaches, which includes criminal investigation and the First Amendment religion clauses. And if you pay attention, she'll also teach you how to think like a lawyer. Next, we'll hear from Mr. Tillman Breckenridge, who is also a double who, and a man whose career is best summarized as being the very best in the business very quickly. He argued and won his first appeal as a 3L in the Fourth Circuit, and then embarked on an appellate career that took him to the Supreme Court and every federal circuit court of appeals. He was elected the youngest fellow and the first fellow under 40 in the American Academy of Appellate Lawyers, and he's a teacher of appellate practice as well. While it is hard to forgive, he founded the Appellate and Supreme Court Clinic at William & Mary Law School. Mr. Breckenridge was the counsel of record in Brennan versus Dawson, which is one of the cases this term that sought to challenge the scope of qualified immunity. Next, we'll hear from Professor Chris Walker, who, while not being a double who, managed to overcome that handicap to establish a stellar academic career. A graduate of BYU, Harvard's Kennedy School of Government, and Stanford Law, Professor Walker has worked in all three branches of the federal government. He clerked for Judge Alex Kaczynski on the Ninth Circuit and Justice Anthony Kennedy on the Supreme Court. He served on the civil appellate staff of the Department of Justice, and he served as an academic fellow for the Senate Judiciary Committee. After the stint working in both private practice and for the government, he landed at The Ohio State University, where he is the John Bricker Professor of Law and easily one of the nation's leading experts on constitutional law, administrative law, and he recently published a qualified defense of qualified immunity, with, if I'm not mistaken, another piece on qualified immunity forthcoming in due course. And last but not least, we're going to hear from Mr. Jason Johnson, who is a graduate of the University of Maryland School of Law and the FBI National Academy. He is the president of the Law Enforcement Legal Defense Fund, which seeks to support and defend the law enforcement profession and those officers who have devoted their lives to upholding the Constitution and to serving their communities, and to educate the public about the many risks and threats that law enforcement personnel face on a day-to-day basis. Prior to joining the Law Enforcement Legal Defense Fund, Mr. Johnson was Deputy Commissioner of the Baltimore Police Department, where he chaired the Performance Review Board, conducting detailed internal reviews of all uses of deadly force by Baltimore police officers. Mr. Johnson has seen all phases of policing firsthand. During a long and storied career with the Prince George County Police Department, he served as a patrol officer, a police academy instructor, a hostage negotiator, a patrol shift commander, assistant commander of special investigations, and commander of legal affairs and internal affairs. And so I think he's going to bring to us just a much needed perspective on what qualified immunity looks like to law enforcement officers that it impacts. And so with our distinguished panel of subject matter experts, I'm looking forward to a lively discussion. With that, I'm going to get it out of the way and turn it over to Professor Armacost. Professor, for those of us who might be new to this whole qualified immunity debate, can you kind of give us the lay of the land?
That would be my pleasure. Philip, it's good to see your face again. I miss you from the law school. And I'm really excited to be on this panel and to hear what all of my colleagues are going to be saying. This is just a really important topic, this topic of qualified immunity. The doctrine of qualified immunity has come under attack. Many argue that it prevents police from being held accountable for police shootings and other uses of force against suspects, but there's some disagreement about that. And I'm sure that we'll have some disagreement on this panel about that, and it'll be really fun to have the discussion. The George Floyd Justice and Policing Act of 2020, which was passed in the House of Representatives, would abolish qualified immunity. And the purpose of this panel is to consider the question of whether that's a good or a bad idea. So as Philip said, my first task on this panel is to try to situate qualified immunity in a broader analysis of claims of excessive force against the police. So first of all, it's important to remember or to learn that qualified immunity is a defense. A police officer uses the doctrine of qualified immunity to defend against a damages claim in a lawsuit brought by the victim under the federal statute 42 U.S.C. 1983. Section 1983 provides a cause of action for damages or injunctive relief against certain governmental officials who violate the constitutional rights of persons living in the U.S. Section 1983 doesn't provide for any immunities in the text of the statute, but the Supreme Court has read Section 1983 against the background of ordinary common law immunities that were in place in 1871 when the statute was enacted. Qualified immunity is one of those common law immunities that was read into Section 1983. But that means Congress has the power to abolish common law qualified immunity by statute, as the House bill seeks to do. An excessive force claim under Section 1983 invokes the Fourth Amendment against unreasonable seizures. Remember, I said Section 1983 allows people to seek damages for violations of constitutional law. So you've got to have Section 1983, plus you've got to identify what is the constitutional right that's been violated. The Fourth Amendment alleges that the excessive force alleges that the police officer used an unwarranted amount of force to stop, arrest, or subdue a suspect. The Fourth Amendment standard for determining how much force is reasonable comes from the Supreme Court case of Graham versus Connor. The operative question in that case is whether the officer's actions were objectively reasonable under the circumstances. Now, you need to know a couple of things about the Graham standard to understand how qualified immunity applies in excessive force cases. So first, the standard is entirely objective. Bad intentions or malice are irrelevant in determining whether force is excessive. This means, among other things, that the Fourth Amendment offers no help in directly addressing force that is motivated by racial bias, malice, or other evil intentions. They just don't enter into the Fourth Amendment analysis. Second, like all objective standards, the excessive force standard is inherently squishy. Whether or not a particular application of force was excessive depends on the particular facts and circumstances surrounding the police-suspect interaction. So every case of excessive force has to be examined from the ground up. The court often offered only limited guidance in Graham on what factors should count. The factors the court did list included the severity of the crime, whether the suspect posed an immediate threat to the officer or to others, and whether the suspect was attempting to evade arrest. As we'll see, the inherent imprecision of the Graham standard makes qualified immunity much more likely in excessive force cases than in some other kinds of cases. Finally, the Graham court made clear that police were to be given the benefit of the doubt in their application of force. The court directed that a particular use of force should be judged from the perspective of a particular officer on the scene at the time. In oft-quoted language from the Graham opinion, the court said, quote, "The calculus of reasonableness must embody an allowance for the fact that police officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving about the amount of force that is necessary in a particular situation," end quote. The court warned against 20/20 hindsight. In other words, looking at the incident and saying something could have been done that wasn't with the information we now have that the officers didn't have at the time. Now, one additional note that's not directly relevant, but I'll just throw it in. While qualified immunity itself is not relevant in a criminal case against an officer involved in a shooting, the Graham standard is relevant. In a homicide case, in connection with an officer-involved shooting, the Graham analysis becomes the defense. The officer will argue that even if what he did would be homicide if committed by an ordinary citizen, it's justified as a reasonable use of force under Graham. As I'll explain later in these remarks, I believe the Graham standard is problematic in some ways, and those ways make it an impediment against police accountability, and it may be as much of an impediment as qualified immunity might be. I'll come back to that point in a few minutes. But let's imagine now that a plaintiff who's been harmed by police use of force brings a Section 1983 case against a police officer. The plaintiff alleges that the officer used an unreasonable amount of force in violation of the Fourth Amendment. In response, the officer will make two arguments. First, under the Graham standard, the officer will argue that the force he used was reasonable under the circumstances. In addition, he'll argue that even if the force that he used crossed the line from constitutional to unconstitutional, he should have a qualified immunity. In other words, the officer is arguing that his illegal conduct should be excused because his mistakes about the exact contours of the Fourth Amendment were reasonable. In other words, qualified immunity applies even if an officer violated the Fourth Amendment unless he violated clearly established constitutional rights of which he could have known. The clearly established law question is asked at a level of specificity, and this is really important. The question is, should the officer have known that the specific acts he took were illegal based on existing case law? The contours of the right in that precise instant must be, quote, sufficiently clear that a reasonable official would understand that what he is doing, actually doing, violated the right. So what does this particularity requirement look like or mean in excessive force context? Well, let me give you one example. In Brosseau versus Haugen, two officers were called to break up a fight involving a guy named Kenneth Haugen. He was a person they knew about. He had an outstanding felony warrant against him for drug and other offenses. There was a confrontation between the police, Haugen, and multiple other individuals. And during that confrontation, Haugen jumped into his Jeep and tried to flee. One of the officers tried to get Haugen to stop, but when he wouldn't, and he tried to drive off, the officer shot Haugen in the back through the rear driver's side window as he was driving away. The way the Supreme Court analyzed the case is instructive. The Supreme Court canvassed Court of Appeals cases with similar facts, namely those involving, and here's the court's words, quote, whether to shoot a disturbed felon set on avoiding capture through vehicular flight when persons in the immediate area are at risk from the flight. Finding that none of the cases squarely governed those facts, the court concluded that the officer's actions fell into that hazy border between excessive force and acceptable force. Now you can see that the specificity that is required to determine if the law was clearly established makes qualified immunity maybe common, or at least more common in excessive force cases than in some other kinds of cases. I know my colleagues will have more to say about that, so I'll leave it there for now. So now, before I finish, now that I've talked about where qualified immunity fits in, I want to go back to the Graham standard for just a few minutes. I said a few minutes ago that I believe the Graham standard itself is an impediment against police accountability in one important sense. So recall that Graham is a totality of the circumstances analysis. But one of the most important things Graham left uncertain is precisely what circumstances count. In particular, what is the precise time frame for the relevant circumstances? So let me explain what I mean. You'll recall, I think, the shooting of Tamir Rice, the 12-year-old black boy who was shot in a park holding a non-lethal airsoft pellet gun. Here are the facts of the shooting. There was a 911 call that came in saying somebody in the park is pointing a gun at people. And the 911 caller said, I think he's a kid, but I'm not sure. I think it's a toy, but I'm not sure. The 911 dispatcher then sent a message to police officers saying somebody is in the park threatening people with a gun, but not adding those two crucial facts that the 911 operator wasn't sure if it's a kid or whether it was a real gun. Two officers responded. They drove their automobile into the park and right up to the person they thought the 911 caller was referring to. One of the officers got out of the passenger seat and immediately shot the individual who the officer believed was reaching into his waistband and pulling out what looked to be a real gun. The victim turned out to be 12-year-old Tamir Rice, and he had an airsoft non-lethal gun. If the Graham standard is applied, as it is by many courts, at the exact moment when the officer pulled the trigger, the shot seems justified. The officer is standing within four feet, I think it was, of a person who the officer thinks is threatening people with a real gun. The person appears to be reaching into his waistband. The shot was required for the officer's own safety in that situation. But if we broaden out the time frame, the reasonableness analysis looks really different. What were the officers doing, driving up so close to a person who they thought might have a gun? Did the officers actually create or help create a situation in which they would inevitably have to use force? Should they have waited for backup? Is there any way they could have de-escalated the situation without coming in so close? Did the officers make sure they had the correct information by staying in touch with the dispatcher? Now, there are some answers to these questions. There's discussion around those questions, but none of those questions are relevant at all if the Graham standard is asked at the precise moment when the shot is taken. Some circuits apply Graham that way, as did the investigators in the Tamir Rice case. All the police investigations found the shot justified. None of the questions I just posed were relevant to the lawfulness of the shot. Now, I want to say, some of those facts are contested and there was conversation, but my point is none of those questions of what happened before that moment of the shot were relevant to the question of the shot, of whether the shot was reasonable. There's a circuit split on this issue of how Graham should be applied. And I think addressing the Graham standard as well as addressing qualified immunity is essential to whatever reforms lead to police accountability. And I'll end there. Thank you.
Thank you, Professor Armacost. It was a wonderful reminder of why you were one of my favorite professors. With the table set, we'll next hear from Mr. Breckenridge. As maybe some of us are aware, the Supreme Court considered nearly a dozen cert petitions relating to qualified immunity this term, ranging from narrowing its scope to eliminating qualified immunity altogether, ultimately granting none. So Mr. Breckenridge, can you give us kind of a flavor of what some of these challenges looks like, and maybe your thoughts on what the Supreme Court might do next with qualified immunity? We may want to unmute you first.
Got it. My apologies. We'll talk a little bit about that, and I just wanted to preface that with, when I founded the William & Mary Clinic, and my apologies for founding it at William & Mary, but UVA already had an appellate clinic that I participated in, so I was a little late to the game on UVA's appellate clinic opportunities. But I had some idea of what qualified immunity was in an academic sense, but I had no idea how outsized a role it would play in our work. As of about 3 years ago, a primer on qualified immunity actually now began to take up about half of my first lesson plan. And I really only get to the tip of the iceberg. It's really been a fascinating journey, particularly considering my experience with police, both personally and as a lawyer. As a lawyer, I've now sued officers, and I've also represented them in a way that has literally saved officers' lives. Personally, I have been the victim of the dreaded DWB, driving while black, on more than one occasion. The most egregious occasion ended with an officer screaming in my face in what seemed to me to be an obvious attempt to get me to touch him so that he would have an excuse to take out whatever frustrations he had on me, all in front of my wife not long after we were married. It's an awful and frightening and helpless and destabilizing experience I wouldn't wish on anyone. As a trained lawyer, you have the right to walk away. As a black man, in that moment that that right is meaningless, and you are at the mercy of this awful person in front of you. And I mean that to be that specific awful person, not painting with a broad brush. The best possible outcome in that situation of exercising your God-given right to walk away is a beating with a club. Now, getting to a little bit of the clinic's work in that capacity, that beating most likely will result in no punishment for the officer, no liability, no accountability. Indeed, the clinic has had a case where a 13-year-old girl didn't know better, illegally stopped. She decided to walk away because she knew she had the right to walk away. She said, "Boo, you can't touch me." And she put her hand 3 feet from the officer's face. He did touch her. He grabbed her arm, he threw her to the ground. He arrested her on the hot pavement. He wouldn't even let her call her mother. Her mom only found her after calling every hospital and precinct in town. The state courts didn't help her. The district court didn't help her. We got involved at the Court of Appeals. They deliberated for over a year after argument and then filed a 3-page unpublished opinion saying they wouldn't help her. Then the Supreme Court denied cert despite a 6-4 circuit split on the particular issue. And this particular circuit not being part of the split because it repeatedly decided the same issue in unpublished dispositions. So, when we talk about what's going on in the courts, the possibility of eliminating qualified immunity, I wanted to talk about how, some people say that eliminating qualified immunity will make no difference, and I get that. Officers are indemnified by their localities almost always, if not always. And at least purportedly, these localities don't often discipline officers even after a bad judgment. Assuming that is true, and I'm not sure I accept the truth of that, there still is value in capping or eliminating qualified immunity. Eliminating severely limiting qualified immunity would also eliminate or severely limit the 2-step inquiry from Saucier v. Katz. And what that is that when courts are deciding issues of qualified immunity, they have to decide 2 things in order to find that qualified immunity does not apply. First, they have to find a violation of a constitutional right. Second, they have to find that right is clearly established. And that's kind of one of the things that Professor Armacost had kind of alluded to when she was talking about the levels of specificity and generality. And then in 2009, the court decided Pearson v. Callahan and decided that the first step was no longer necessary. The court doesn't have to decide whether a right was violated. The court merely has to decide whether the right was clearly established. And if the right wasn't clearly established, then they don't have to decide whether there was a right violated at all, the asserted right. And so what that does is that creates a system where the court doesn't have to decide if the right exists at all. As a result, few cases receive a judicial explanation of whether a right was violated, meaning courts, and more importantly, officers and departments don't get the guidance they need to properly develop training regimen that make officers act in a safer way. The clinic has won numerous qualified immunity cases, probably most of them actually. Indeed, just a couple of weeks ago, it won for the 2nd time in the same case on behalf of a teenager who was tased by officers purportedly for her own safety. the clinic has also lost a number of them, heartbreaking cases. Among them, one of the 8 petitions that was repeatedly reconferenced until just a couple of weeks ago, Brennan v. Dawson. My last case with the clinic, which I know will be passing on to a couple of wonderful successors. And in Brennan v. Dawson, well, you have a situation where it seems somewhat minor, and it arguably is. You have an officer who's trying to get a breathalyzer test from a probationer. There's a little bit more nefarious character to it when you take into account the officer did this while the magistrate who presides over these kinds of things was out of town, and they would wait until this magistrate was out of town or otherwise unavailable because she didn't want them doing this. When he didn't answer the door, you have an officer who this was after hardness was decided by the Supreme Court, which says that officers can knock at the front door. They have the same license as any other person, but then that's it. If no one answers, they have to leave. A little bit before that, you had the Sixth Circuit having decided that officers could go around the back and knock on the back door. And then you have this officer who circles the house 5 to 10 times, banging on doors and windows, tears down the security camera at the door, and then blares his sirens all over a 2-hour period, never leaving the property. And you have the Sixth Circuit, and I'm sorry to say, your judge, ultimately deciding that that this prior precedent in the Sixth Circuit saying that you can go around to the back and knock created a situation where, regardless of hardness, it was reasonable for an officer to then think that he could circle the house 5 to 10 times, banging on doors and windows, waking up the whole neighborhood, which was actually part of the phrase, or half the neighborhood. I think it was a phrase particularly used. And tearing down a security camera, and there was no clearly established right against this, despite the very clearly established right against intrusions on the curtilage. And along with my case, and I will get to a little bit to what we were going for in a second. In that case, you had a host of other cases, and they're basically a few categories that the qualified immunity work falls into. First, there is eliminating qualified immunity through the courts. That doesn't seem to be much of an option at this very moment because of the results of all these petitions, but Justice Thomas gave a bit of a roadmap in his Baxter dissent from denial. I worry about how feasible that roadmap is, because it basically requires test case type collusion from both the plaintiff and defense side. And I haven't run across a whole lot of municipalities that are going to really try and help you get a cert petition up to eliminate qualified immunity. But you never know. Maybe you'll find one that really wants to go after what constitutes state acting under the color of state law and is willing to take the shot. Now, the second category is making qualified immunity make more sense. And that's the route that I and the clinic have chosen. So we try to get precedents that give guidance on the reasonable scope of the doctrine. Unfortunately, too much of it has already been set by the Supreme Court in a weird and foggy way. And so the court has not been particularly willing to fix its mess. So you have cases like Brennan v. Dawson, where our hope was to cabin the doctrine by having a question presented that says, to the extent that someone is relying on an exception to a clearly established right, because our client, Mr. Brennan, had a clearly established right against officers going around and going through the curtilage and rummaging through the curtilage and banging on doors and windows and everything like that. And then there was this exception created by the Sixth Circuit, where the Sixth Circuit sort of accepted that there's this exception where they can go in this prior case where they can go around to the back door, and a reasonable officer might not think that's abrogated by hardness. And then our question was, well, once you've been given that exception, can you then use qualified immunity to claim it's reasonable to grossly expand that exception? And so the hope was to then, work incrementally, as the Supreme Court particularly these days likes to do things, to hopefully cabin qualified immunity in a reasonable way. In another case, we were looking for a workable standard on the level of generality at which the right should be defined. So one of the things that Professor Armacost alluded to, which is a fascinating standard because the court just says things can't be defined at too high a level of generality, but gives absolutely no guidance as to what that is, or how to determine what's the appropriate level of generality is. There's just a handful of cases out there where they say, no, this is too general, this is not general enough. And so we were looking to push a standard to that the level of generality is determined at the point at which factual distinctions don't make a legal difference, which seems simple enough to us, but oddly enough, there are plenty of cases where courts have decided that, factual distinctions that don't make any legal difference whatsoever, and obviously do not make a legal difference, are enough, and qualified immunity applies. And there's a small handful of cases that go the other way as well that I think need correction too, where they decide that where the court just defines it as super high level of generality and says the Fourth Amendment says that you can't be searched or seized without probable cause, and so therefore, you have a clearly established right. And there is a happy medium, and the guidance just needs to be there on that. And then, of course, third, there's helping with the legislative effort. And I will admit that, as we talk about the future of qualified immunity, I am pessimistic about the possibility that Congress will come up with a workable solution and actually pass it. So I was, of course, very disappointed when the Supreme Court eliminated all the petitions, both the ones trying to get rid of qualified immunity and the ones just trying to narrow qualified immunity, as soon as those bills were were offered up. Because it seems unlikely to me that that will happen, but to the extent that you're interested in this topic and interested in getting involved, litigation is not the only way, and you can try and do whatever you can to help with the legislative effort to fashion something that makes sense. And there may be a host of other ways to assist. The bottom line is that this is a sad example of a doctrine of what happens when well-meaning judges make policy decisions that's untethered to any text. Because if you look at the game of judicial telephone that has come out of qualified immunity, it was originally this concept that harkened back to the common law thought of, basically a good faith privilege that turned into this objectivity test that then turned into this kind of monster that grabs up a whole lot of cases that it shouldn't. And in any event, even if whatever happens in Congress, there will be a role for people in this audience to play in qualified immunity jurisprudence going forward in the courts, because even if Congress does pass a law, there will still be a bazillion cases coming along that seek to interpret what exactly Congress puts into this law. So going forward, even though all those cases were denied, ultimately, the courts will still play a huge role in determining the future of qualified immunity. And with that, I'll pass it along.
Thank you, Mr. Breckenridge. And you gave us a great jumping off point for Professor Walker, who is going to talk to us, I think, a little bit about some of the legislative efforts to reform or eliminate qualified immunity, the roles that states can play in officer and government official liability. And it's a helpful reminder that, ultimately, the courts are not the only option here. So with that, Professor Walker, the floor is yours.
Great. Well, it's so great to join this terrific panel and to talk about something that's, at the forefront of legislative and judicial debates and reform, potential reform. And I want to just kind of step back and talk a little bit about, Aaron Nilsson and I have written a fair amount on qualified immunity. And we're one of the few, I think the reason I'm on this panel is if you Google defend qualified immunity, I think we're the only ones that show up. And our defense in the past has been focused more on who should reform it. And I'm not going to spend too much time on that because I think in the Q&A we can talk about that a little bit more. But our basic argument is that it really shouldn't be the court that overturns precedent, that it should be something less left to the legislative process. And the reason for that is that qualified immunity has been a precedent of the United States Supreme Court since the 1960s. It's been repeatedly reaffirmed over the decades, and it's something that state and local governments have legislated and contracted around. And so there were reliance interests there as well. And I think this is one reason why you saw the court, pull a bunch of these petitions and sit on them and think about them for a while, but ultimately didn't do anything with them. And I think that's because of statutory stare decisis. In other words, the concern is that the Supreme Court doesn't just get rid of a prior precedent that interprets a statute because it's wrong. It's got to have more than that, because the worry is that it's not just that the court is using its capital to undo something, but Congress can always jump in and address the issue as well. And so that's kind of the idea of statutory stare decisis that Aaron and I explore in our article, is that, hey, this has been a doctrine of the Supreme Court for a long time. It's interpreting a statute. Congress has actually legislated against the backdrop of this statutory precedent. They've actually embedded qualified immunity in other parts of the U.S. Code, and they've amended Section 1983 to address other immunities issues without touching qualified immunity. And so even if you think it's wrong, court, you should leave it to Congress. And that's kind of the idea. Now, stare decisis generally is a very hot topic at the Supreme Court right now, with Justice Kennedy being replaced by Justice Kavanaugh. You can imagine just generally a court, if you're in the liberal bloc of the court, maybe not wanting to get too aggressive in undoing precedents. But it's particularly important in the statutory context. And the Supreme Court has said, well, in the constitutional context, if we're overturning a constitutional precedent, then we'll have a lesser standard than a statutory, because it's much harder to amend the Constitution to fix the court's error. But when it comes to statutory precedents, we have Congress, and that's kind of a role from a separation of powers perspective. Now, is it actually wrong? I think almost everyone agrees that Section 1983 incorporates the backdrop immunities that existed when the Civil Rights Act was passed. Ann Woolhander at UVA has done a really fascinating deep dive into this and has kind of concluded that, well, this is messy. We don't know. Sure, we have absolute immunities for judges and legislators. There are some good faith immunities for executive officers that seem to have pre-existed the Civil Rights Act. No one's really arguing it is exactly what it is today with an objective standard, but I do think it's a messy history there, and that would also kind of counsel against the court overturning qualified immunity. Now, Aaron and I, and I'll just put this in the chat in case people want to read this later. We have a piece coming out in Georgetown that looks at the federalism dimensions of this. And I don't want to spend too much more time on that because I want to get to the legislative proposals and kind of talk through them, but just kind of highlight that if the court's really going to engage in an effort to overturn qualified immunity, it's going to have to also look at reliance interests. And we make an argument that qualified immunity is actually, even though you're suing individuals in their individual capacity, you're not suing the state under Section 1983. Ultimately, qualified immunity is there to actually protect state interests that include hiring and retaining qualified officers, allowing those officers to do their jobs instead of being tied up in litigation in court and depositions, and also trying to strike the right balance of deterrence, of encouraging officers to do their jobs while discouraging them from violating the Constitution in a clearly established way. And those are the reasons the Supreme Court's given for individual officer liability. In this article, we argued those are actually sound in federalism, that they sound in trying to protect state resources and states' rights along those lines. As Mr. Breckenridge mentioned, also officers are almost fully indemnified under state law these days. And so you also have that type of federalism interest that you might want to think about. And the last one I would just kind of flag that we do in the paper, and maybe I'll turn back to this so we have more time later, is the idea that states can actually get rid of qualified immunity under their state law. Now, they can't get rid of federal qualified immunity. Section 1983 still has that, but they can create liability for officers under state law, and they can remove any types of immunities that those officers may enjoy. And in fact, they do this. In California, for instance, they have narrowed and gotten rid of qualified immunity for certain police actions. In Colorado, just last week, they abolished qualified immunity at the state level. State Supreme Courts have narrowed qualified immunity in very important ways to reintroduce a subjective intent standard, for instance. And so states also can play a role here in reforming the doctrine. Now, I'm going to spend the last few minutes talking about the legislation because, as you remember, Aaron and I's argument is that Congress should do this. And if none of you have read my stuff, but I write a lot on Congress's role, and I really think Congress should play a much more important role in revising old statutes and trying to kind of calibrate them to modern times. And you have some examples here of legislation that's been introduced in the wake of the killing of George Floyd and the protests that have ensued. And there are kind of three main pieces of legislation that are on the table right now. And I'll go kind of from what I think is the broadest to the narrowest. The broadest is the Amos-Presley bill that would get rid of qualified immunity entirely for everyone, for every state officer. It doesn't provide any exceptions. It doesn't, for instance, just focus on law enforcement as opposed to public school teachers or social services workers. And so it's kind of the broadest one. I don't think it has any chance of getting bipartisan support that it would need in the Senate to be passed. The next one is Senator Braun from Indiana, a Republican, has introduced a Reforming Qualified Immunity Act that is almost as broad as the Amos-Presley legislation, but it creates two exceptions. An officer would still be immune from suit and damages if the officer was following state law that had not been declared unconstitutional yet. And it would also be immune if the officer was following a binding precedent of a court that says that you can do that or that you have to do that. So those are kind of two exceptions. My guess is those exceptions are going to have to be in any piece of legislation that has a chance of passing, because it would be somewhat weird to have a Supreme Court decision that says that you can do this and then still have that person be held liable for doing that. And so that's kind of one example. The narrowest of the three is somewhat ironically, it's the Justice and Policing Act that the Democrats in the House have put forward as part of their comprehensive reform of the criminal justice system and policing. And why I say it's narrower is that it only applies to law enforcement officers. It doesn't apply to other state actors. And so I think that's kind of one interesting wrinkle there. It's more narrowly tailored to address the current issues along those lines. I think it still has a pretty steep climb to get support from Republicans in the Senate. But I do think it shows why, another reason why a legislative reform might be better than a judicial reform, because you can actually focus on just one particular type of state actor and the like. Now, I'll just want to throw out a few more that I think actually could get more bipartisan support if they were advanced. The first is, instead of focusing on the actor, focus on the action. So instead you could say, there is no qualified immunity for claims of excessive force under the Fourth Amendment brought under Section 1983. Or if you wanted to have it narrower, you could say for excessive force that led to a wrongful death, so deadly force, right? Or if you want it broader, you could say for any claim under the Fourth Amendment. So it would include other types of searches and seizures, not just excessive force. I think that's one way to kind of narrow the House Dems proposal. If you want to go even narrower, you can get into some of the details of qualified immunity. And these ones, I actually wouldn't at all be surprised if someone like Senator Lee introduces something like this, if they get an amendment on one of these bills. One would be to actually overturn Harlow versus Fitzgerald, which is a 1982 decision. Before, with qualified immunity, and this gets back to Professor Armacost's discussion of excessive force, before with qualified immunity, you could actually get over qualified immunity in one of two ways if you're a plaintiff. You could say that the officer was objectively unreasonable, that they violated clearly established laws established by the circuit court or the Supreme Court, or you could allege and prove that the officer had the subjective intent to violate the constitutional rights, whether they're clearly established or not. That's a really powerful way to get around qualified immunity. It still doesn't get around Graham, which may or may not be a good thing. As a bipartisan compromise, it might be a good thing, because you still have to, at the end of the day, show that the officer was objectively unreasonable, but you don't have a defense from suit at the outset. You can't be kicked at the motion to dismiss page on this. So that's kind of one way to do that. And then the last reform, which strangely is probably not even a reform because it's a Supreme Court precedent, but there's a case called Holt v. Peltzer that Justice Stevens authored back in 2002 that said, one of the big criticisms of qualified immunity is that you have to, as Mr. Breckenridge was saying, you have to find a case that's like on all fours, identical facts to provide the notice that you need. At least that's the way a lot of these decisions have, played out. There's actually a Supreme Court decision that says you don't have to do that, that you don't have to find a case in all facts. As Justice Stevens said, fair notice does not necessarily require a binding precedent by the Supreme Court. A general constitutional rule already identified in the decisional law may apply with obvious clarity to the specific conduct at issue, even though the specific action question was not previously held unlawful. That decision does not get cited by the Supreme Court in cases. This idea that as long as a court has provided enough guidance so that a reasonable officer would know that they're violating the Constitution, you don't have to find an identical case. I think it's a very narrow way to amend qualified immunity, but I think it's a really powerful one to kind of get back to a more of a good faith defense, or more of a fair notice defense, as opposed to kind of a hyper-technical, have you found the right case that's on all fours approach. So those are some of the congressional legislative attempts at reform. Just to kind of conclude, Senator McConnell has made it very clear that this is a poison pill and that qualified immunity is not on the table. But I spent a lot of time answering the phone call from members of Congress on the Republican side. And I would say that both in the Senate and the House, there actually is a lot of interest in trying to find a legislative solution that's short of what the House bill wants to do, but still recognizes that the current standard does not provide enough protection and incentives for officers to take their constitutional duties seriously. So I'll stop there.
Many thanks, Professor Walker. It would be remiss for us not to consider qualified immunity from the perspective of the group that is arguably the most impacted by it, and that's the law enforcement officers that qualified immunity tends to protect. And it's not difficult to imagine that eliminating or reforming qualified immunity would represent a massive change for the law enforcement community. In fact, that's sort of the point of these efforts. And so I want to turn it over to Mr. Johnson to ask, how do you see some of these proposals to change or eliminate qualified immunity impacting the work of law enforcement? Are these positive, negative, mixed bag? And with that, the floor is all yours.
Great. Thank you, Philip, for the introduction and for the question. Thank you to the Federalist Society for inviting me. I appreciate the opportunity to offer my voice to the conversation, and of course to my colleagues on the panel for their comments. I've already learned a few things just in the little while I've been listening to them. I've learned a few things probably from each of them. What I would hope to offer really is just that, is a perspective from law enforcement. Speaking as a person who spent a career in policing, as a patrol officer and in a variety of other capacities, also in a senior leadership role in a large law enforcement organization that has challenges, frankly, with excessive force, with racially biased policing and so forth, subject to a federal consent decree that in Baltimore. And into my current role, where I sit now, we're an advocacy organization that we work to defend law enforcement officers who are, in our view, wrongfully charged criminally with offenses that arise out of their duties as law enforcement officers. So I think I come at this from a number of different perspectives. I am not, although I'm an advocate, I'm not a blind advocate. We're not blind homers for policing. Police officers are not always right. Sometimes they're wrong, and they certainly should be held accountable when they're wrong. So we're not looking for the proverbial get out of jail free card. But I do, from my perspective, I do support some version of qualified immunity. I think it's critical, and in my comments, I'm going to try to paint the picture of what it's like from the very perspective of law enforcement officers who are often responding to dangerous and rapidly evolving situations and have to respond to those situations to provide for the public safety. But the key thing here is that at the end of the day, as Professor Walker said, law enforcement officers, or really any state actors, have to be free from being frivolously sued repeatedly, from spending all of their time responding to depositions and attending various court proceedings related to their duties, and actually spend most of their time pursuing the work that the people pay them to pursue. So the idea really is to have some mechanism to cut off cases in an early stage that, frankly, where the officer's discretion, the officer exercise their discretion in a reasonable way. And I think the question is how do you pen that in? How do you figure out what classes of cases are clearly established, where the law is clearly established and the officers followed their training, followed their understanding of the law, recalling all the things that I'm getting ready to say about the law enforcement perspective. Police officers, wherever you are in the country, are typically the officers who are responding to the most dangerous, rapidly evolving situations where they're exercising this judgment that we talk about, exercising their knowledge of the law, tend to be in their early to mid-20s. Many are not college graduates. Very, very few have attended law school, although they've been trained in the basic laws that police officers operate in their environment, heavy on Fourth Amendment and police use of force. But they don't have the luxury of obtaining legal advice on the scene of an incident. Certainly it would be impractical for them to seek a legal opinion when responding to a call for an armed person, or when attempting to place someone under arrest and they begin resisting arrest. In order for that officer to decide what to do, they rely on their training. So certainly it's incumbent upon law enforcement agencies to adopt responsible policies and to provide comprehensive and thorough training in those policies so that officers are best equipped to respond in a reflexive way and in a way that is consistent with clearly established laws that apply to law enforcement officers. But another, I think, issue that came up had to do with recruiting. There is a huge challenge in the United States right now across the country, large agencies, small agencies, it doesn't really make a difference, to recruit people who are willing to serve as law enforcement officers. This has been an ongoing crisis really since about 2014. And I think those of us in the law enforcement community are really concerned that it's going to get worse. And qualified immunity, the duty or the requirement that employing law enforcement agencies or their municipalities are required to indemnify officers. I know that's a matter of state law. Many states require municipalities to indemnify police officers. So when we talk about qualified immunity, if all of a sudden qualified immunity went away, if the thought is that officers will still be protected and therefore it won't impact recruitment and retention of police officers, won't impoverish police officers, I think we have to remember that the states could easily roll back their laws that compel municipalities to indemnify their officers, in just as if qualified immunity is rolled back by Congress, either in whole or in part, the states can respond in kind. There's tremendous political pressure in state legislatures to eliminate anything that appears to support or defend police officers who are doing the wrong thing. So I don't think we should presuppose that any laws or regulations that require indemnification of police officers will remain in place. So really it comes down to what is going to protect a police officer who's acting in good faith in a reasonable way, and if you use the objective reasonable standard of Graham versus Condor, that's fine, and is acting consistent with their training. It does not have the subjective intent to cause anyone harm or to violate anyone's rights. If that police officer is at risk for being sued successfully for damages, and there's a potential that they could not be indemnified and they could therefore be impoverished for doing a difficult job under difficult circumstances, having to make split-second decisions without the benefit of legal counsel, without the benefit of legal training. I think it presents a very scary situation where I think we do have real difficulty, not only recruiting and retaining, but just getting police officers to function in their day-to-day discretionary decision-making. Much of police work is discretionary. Decisions to stop a particular car or stop a particular individual based on suspicious behavior. All of those actions that have become a part of police work, and when done lawfully and properly, are important to protect the public safety. All of those things would be jeopardized, in my view. I think police officers would be much more risk averse. Any discretionary decision making that could result in a judgment for damages, officers would avoid. It seems reasonable to me that you would want to avoid those sorts of contacts that you know could result in liability. And so I think it just presents it presents a very scary environment for police officers to operate in. Now, having listened to my colleagues on the panel and their comments, I mean, I would agree that it's sort of ironic that the defense for police officers that they can protect them when the law is not clearly established itself is not clearly established. It doesn't seem clear at all based on the various Supreme Court cases and appellate decisions over the years, the specific circumstances or how trial judges are supposed to determine when qualified immunity applies and when it doesn't apply. It seems very confusing maze of cases. It should be clarified. I think it should be much. It's easier said than done. But these rules as to when qualified immunity does apply and doesn't apply, they should be much more easily determined in trial courts. And so I certainly would agree with that. I don't necessarily think that qualified immunity as it exists today doesn't need to be fixed. I do think that there are areas that we can all agree need to be improved upon to make the environment easier to predict, both for police and for police agencies, and also for potential litigants and counsel and trial judges to apply those rules in a way that's fair and in a way that's predictable for everyone who's involved in the system. And with that, I'll wrap up.
Well, thank you so much, Mr. Johnson. With our panelists, I think now having all spoken, we're going to open it up for questions, and there are a couple of ways that you can ask questions. One is to use the chat feature, and the other is to use the raise hand feature. And basically, we'll take questions until one of the panelists tells me they have to leave, or Rachel tells me I have to shut up. So I will, while you guys are thinking about questions, I will take the first one, which is to ask, in 2009, you had Justice Alito writing for a unanimous court, if I remember right, Pearson v. Callahan, which basically told courts of appeals that they no longer had to find a violation first if they could find that even if a constitutional right has been violated, it wasn't clearly established. And some critics have said it basically ossifies the law because no one is going around deciding whether there are constitutional violations occurring. So I'll sort of broadly say to the panelists, what are your thoughts on the impact that Pearson has had on qualified immunity, and maybe whether that's a first step to look at as a way of reforming qualified immunity? I will also ask you to think about another question in the background, which is, what's the best argument that you're wrong? So who wants to start on Pearson?
Well, I was clerking for Justice Kennedy when Pearson was decided, so it's a case that I spent a lot of time thinking about. It's a dilemma. I mean, I can say, in the court, I think it was just 8 years before Pearson and Saucier, required lower courts to decide the constitutional question first. It led to a lot of decisions the Supreme Court didn't like. A lot of decisions on constitutional issues that the Supreme Court thought were wrong. Some of those were based on cases that were really poorly lawyered. Some of them are based on cases where the facts had to be, assumed true at the pleading stage, but probably weren't actually the facts once you had discovery. Some of the justices felt like the courts were issuing advisory decisions because there was going to be no relief granted. And Justice Kennedy, for instance, has written that he thinks this actually might be unconstitutional. I don't think he's right, but, and so the court was operating against that backdrop and then said, all right, well, now we're going to say courts have the discretion, and Justice Alito, writing for the court, provided factors that the lower court should consider, including, is this going to come up in another context, like a criminal case, for instance, or could it come up in a case against a municipality where there's not qualified immunity? Is the lawyering good? Things like that. Is this a recurring issue that's going to escape that? If it is, then you should answer the question. And so I think the court tried to provide guidance. It was written by Justice Alito, so there were like 12 or 15 factors against reaching the constitutional question and 6 in favor, which I could imagine writing that decision differently. You could put a not before all the, anyway. And it has led, there's the Reuters, this really impressive empirical study has come out, and they conclude that after Pearson, police officers win a lot more than they used to. Now, I'm not sure getting rid of that's the best approach, but I do think it's something to kind of keep in mind that maybe this kind of encouraged courts to go in the wrong direction in recognizing new constitutional rights.
I guess I'd completely agree with that, it's created a really bad incentive, particularly for the circuit courts of appeals. Insofar as, there's one Fourth Circuit or former Fourth Circuit judge that I know who used to love to say, what's my exit ramp? What's my exit ramp? And this, this served up an exit ramp on a silver platter. At the same time, I completely agree with some of the things Professor Walker said about how without Pearson, you had just this slew of cases stating that certain rights exist and certain rights don't exist. And so that's how you end up with a unanimous opinion in Pearson v. Callahan, because you have justices who are looking at opinions and saying, wow, these are just so wrong on either side. And so that's the danger. And I think that I think cabining it to Pearson v. Callahan is a dangerous thing to do. And so I would not suggest just eliminating Pearson v. Callahan, because it would create kind of the opposite. It would create the pre-Pearson problem to try and solve the post-Pearson problem. But the bottom line is that the mess that qualified immunity is right now is a result of several different lines of bad decisions. And so just cutting one out, well, I don't think it solves the problem. I think it just changes the problem. And cutting out Pearson v. Callahan, I don't think it would make anything better. I think it would just make it different.
We have a couple of audience questions, starting with one from Chris Coleman, asking, is police training taken into account when trying to decide whether officers are culpable for breaking an established right? And would it be possible to sever qualified immunity as a defense in criminal and civil courts?
Well, in my experience, I will go to a Ken Abraham quote. It's evidentiary but not dispositive, that he used to love to say. And in the end, it's not strong evidence. So, having looked at a bazillion qualified immunity cases, doing the work that I've done with the clinic, a whole lot of cases brought up that this officer violated stated clear policy of their departments, and it doesn't tend to carry much water.
Yeah, and this gets back to what Professor Armacost said at the beginning, that the standard today is an objectively reasonable standard. So it's only, they don't even look at what that officer knew or did or intended to do. They just look at cases, at judicial precedent. Now, I think on the flip side is, one thing that qualified immunity has done is that when there's a precedent that comes down, like I'm in the Sixth Circuit, I have the attorneys from the Columbus City Attorney's Office come into class. they have comprehensive training on the cases as they come down. If that makes sense. So like this new case from the Sixth Circuit came down and you can't use tasers this way, or, you know, I think that's a good thing that there is training, and it's intended to reduce constitutional violations and also intended to limit liability in Section 1983 cases. But one thing that would happen if you made qualified immunity weaker, I think at least, is that sophisticated police departments would train even more and not just focus on the cases, but focus on the broader principles of the Constitution in ways that they don't right now. I do think there's kind of a myopic focus on, you know, on what the cases say and not what the constitutional principle is that's kind of motivating those cases. I think you'd have better training in some ways if you had a weaker qualified immunity.
I think from a police training perspective, it's very difficult and very challenging for law enforcement organizations to respond consistently and appropriately to new appellate cases that address sometimes very, very narrow issues. It's almost impossible for them to do that in real time because you know, police officers typically, after their initial training, they may come back like once about a week every year for in-service or refresher training, occasionally more often than that, and it's just exceedingly difficult for employing agencies to keep up with that and to, you know, provide meaningful training, not just a mention in a PowerPoint slide, but meaningful training that corresponds with some of the really, really narrow. I mean, I think that's why the conversation about how broad a legal principle has to be clearly established is an important one, because, you know, really it comes down to police officers performing in these stressful situations. And we want, you know, police officers have a vitally important job for the public safety, but also their actions can really harm people. So we want them to have a very finely tuned sense of what is appropriate and lawful and consistent with the law, clearly established law, the Constitution. And it's just very difficult for agencies to figure out exactly how to do that. So it's a challenge. And I think a lot of agencies historically, qualified immunity or not, have not learned the lessons from civil litigation to sort of bring back the lessons that they learned at the end and apply them in a way to train their workforce things to avoid. Some progressive agencies have done that well. Others are adopting it as we move into the era of police reform. But it is something for them to do. And anytime any municipality loses a lawsuit, there should be a lesson in there somewhere so that they can take what they learned from that and have their officers avoid that in the future. If they didn't learn anything from it, they just paid damages. I don't know who that really helps other than that one litigant.
Yeah, I think the training is often, and Jason, you can tell me whether I'm right about this, but the training is usually, I mean, I've been amazed at how detailed the police knowledge of cases is. And it's not just Supreme Court cases, but it's cases in their jurisdictions. I mean, I have done some police training and I've been really impressed about that. But police training can't, like you know, I mean, I talked about the Broussard case. You can't have a police rule that accomplishes, like, that gives you a rule in that very specific situation about a fleeing Jeep and a fleeing felon and with lots of cars around. Like, the training is going to be very broad. You know, if a Supreme Court case comes down and says no chokeholds, well, then you have training that says we're not doing chokeholds anymore. But, you know, most cases at the Court of Appeals level are specific, and that's what the qualified immunity is looking for, and that's what Graham is looking for. So police training is not going to be very helpful on either side. It's not going to be helpful on the side of I did what my training told me, and so therefore I'm exonerated, right? And it's not going to help on the other, it's not going to make it worse on the other side. You know, you violated training. Well, if you violated training that didn't violate the Constitution, that's going to be irrelevant too. So yeah, I think the training is important, but I don't think it's really dispositive in these cases.
Rachel, if you wouldn't mind unmuting Michael Patton, I believe he has the next question for us. Michael, fire away.
Okay, can everyone hear me?
Yes, sir.
Okay, great. So this question is actually directed at anyone on the panel that would like to comment. My question is, do you think that increasing the use of body cameras will decrease the need to significantly reform qualified immunity? For example, in the case with the 13-year-old girl that Mr. Breckenridge mentioned, wouldn't video evidence of the abusive behavior by the police officer make the case for clear abuse of authority easier against the officer? And if we were to increase the use of body cameras, then it's not just the word of the officer against the word of the victim.
Well, I'll take it's anecdotal to refer specifically to that case, but in that case, a camera apparently wouldn't have made a difference because they were taking the facts in the light most favorable to my client. That, and actually there actually was no dispute of fact. The officers admitted the whole interaction, everything was actually completely agreed upon as far as the factual situation. So I don't know that a camera would have made a difference. And yeah, I'm a big believer in cameras. I think that, I believe in a lot of the statements that, that nothing is increasing. It's just that it's getting on camera more than it used to be. And so I do think it is a good deterrent, but it's not a 100% effective deterrent. And so I think that qualified immunity still does need to be reformed regardless of the future prevalence of body cameras.
I'll just say from my perspective, if I can, I don't really know the interaction. The real call of your question has to do with qualified immunity in the context of broader application of body-worn cameras by police. I don't know the answer to that, but I will say that I think body-worn cameras are helpful in these police cases because they're certainly, I don't think police excessive force is increasing or police misconduct is increasing. I don't see any evidence of that. I do think we do see it more because sometimes there's video evidence of it, and it's stuff that was hidden or sort of unprovable or wasn't as clearly provable until we saw it on camera. But I would just say, just as a note of caution, that I'd be derelict in my role if I didn't throw this out there, that body-worn cameras are helpful, and they can assist with timelines. Sometimes they can show some things that are helpful in an investigation. Often they do show things that are helpful in one way or the other in the investigation, but they are not. They should never be taken as a substitute for a full investigation that includes all of the traditional investigative steps, forensics, interviewing witnesses, and things of that nature. That you really cannot watch a video and conclude what happened. It's just like anything else, it's a piece of evidence.
Well, Professor Walker, you were kind enough to share with us some resources on a qualified defense of qualified immunity. So who should we be reading for the other side of that argument?
So I think on the legal points, Will Bode's article, "Is Qualified Immunity Unlawful?" is probably the kind of the newest and best treatment of that. It came out in the California Law Review a few years back. On the policy points, I think hands down the most interesting and creative empiricist is Joanna Schwartz. And I linked to her kind of response to our piece, but she's done about 8 or 9 empirical studies on various aspects of qualified immunity that are really important. And so I think that's kind of one, if you're looking kind of for the summary of those, she has a piece called "The Case Against Qualified Immunity" in the Notre Dame Law Review that kind of gives a nice summary of all of the reasons why. Those are the ones that come immediately to mind.
It appears we have reached the appointed hour. So if there are no further questions, I think I'll turn it back over to Rachel, and we will wrap up this evening with, on behalf of both the UVA chapter and all the attendees, my warmest thanks to all of our panelists for a wonderful discussion, and I appreciate you letting us borrow some of your time tonight.
Well, thank you so much, Philip, and thank you to all of our panelists this evening. This was a wonderful discussion, and we really appreciate you taking the time to talk to our chapter. So thank you all, and everyone have a wonderful evening.